Remoteness of damages. Intervening act or events, Novus actus interveniens. Damage resulting to the plaintiff after the chain of causation set in motion by the defendant's wrongful act is snapped is too remote and does not qualify for award of damages against the defendant. The proposition so stated is simple, but the difficulty lies in formulating the principles as to when an act or event breaks the chain of causation. The snapping of the chain of causation may be caused either by a human action or a natural event. As regards human action, two principles are settled. One, that human action does not per se sever the connected sequence of acts. In other words, the mere fact that human action intervenes does not prevent the sufferer from saying that injury which is due to that human action as one of the elements in the sequence is recoverable from the original wrongdoer. And secondly, that to break the chain of causation it must be shown that there is something ultroneous, something unwarrantable, a new cause, which disturbs the sequence of events, something which can be described as either unreasonable or extraneous or extrinsic. If there is a duty to avoid risk to children, their unexpected behavior does not break the chain of causation, for their ingenuity in finding unexpected ways of doing mischief to themselves and others should never be underestimated. Rescue cases illustrate the principle that a reasonable act done by a person in consequence of the wrongful act of the defendant does not constitute novus actus breaking the chain of causation. It is reasonably foreseeable that if the defendant's wrongful act has put a person in danger of death or personal injury, some other person may come forward to effect a rescue even by exposing himself to the same risk, whether or not the person endangered is one to whom he owes a duty to protect or is a mere stranger. The rescuer can, therefore, claim damages from the defendant for injuries suffered by him in effecting a rescue unless his act was a foolhardy act or wholly unreasonable. Where the novus actus is caused by an irresponsible actor, it does not break the chain of causation. Anyone who invites or gives opportunity to mischievous children to do a dangerous thing cannot escape liability on the ground that he did not do the wrong. Recklessness of a third party, as distinguished from his mere negligence, may break the chain of causation and constitute novus actus interveniens. A car broke down at night in fog on dual carriageway. The driver of the car was negligent in leaving the car on the carriageway instead of moving the car onto the verge. A lorry driven not merely negligently but recklessly collided with the stationary car and then went out of control. The lorry ended up overturned on the opposite carriageway. This would not have happened but for the reckless driving. Two other cars collided with the overturned lorry. It was held that the lorry driver's reckless driving broke the chain of causation, and it was the sole cause of the accident on opposite carriageway. In Simmons v. British Steel Pick, Lord Rogers summarized the principles involved in considering the question of remoteness of damage. The summary reads, "These authorities suggest that, once liability is established, any question of the remoteness of damage is to be approached along the following lines, which may, of course, be open to refinement and development. 1. The starting point is that a defender is not liable for a consequence of a kind which is not reasonably foreseeable. 2. While a defender is not liable for damage that was not reasonably foreseeable, it does not follow that he is liable for all damage that was reasonably foreseeable. Depending on the circumstances, the defender may not be liable for damage caused by a novus actus interveniens or unreasonable conduct on the part of the pursuer, even if it was reasonably foreseeable. 3. Subject to the qualification in 2. If the pursuer's injury is of a kind that was foreseeable, the defender is liable, even if the damage is greater in extent than was foreseeable or it was caused in a way that could not have been foreseen. 4. The defender must take his victim as he finds him. 5. Subject again to the qualification in 2. Where personal injury to the pursuer was reasonably foreseeable, the defender is liable for any personal injury, whether physical or psychiatric, which the pursuer suffers as a result of his wrongdoing.